My name is Brian Cronin, and I'm very pleased to welcome you to this tutorial on approaching the EQE, the European Qualifying Examination for Patent Attorneys. This is the first approach serving the client. This tutorial is part of a series of audio slideshows entitled Approaching the EQE, made up of 6 complementary approaches. The first approach is serving the client, which is this tutorial. The next will be the working method. This will be followed by legal thinking. Number 4 is presenting arguments. Number 5, substantive law. And the final tutorial of the series is time management. Here we will deal with the first approach, serving the client, and I hope that these approaches have a positive effect. Namely, I hope that the approaches should complement your work on the individual EQE papers. They should lead you, hopefully, to adopt a common approach to all of the EQE papers, so your work on each paper will help you for the other papers. Moreover, I hope it will assist you in obtaining maximum benefit from the work that you put in, and it will help you to adopt a positive attitude to the EQE. Lastly, I hope it will help you to coordinate your exam preparations with your everyday work. Those then are my hopes of what you will achieve by following the approaches. Let's now go ahead with the first approach on serving the client, starting with the task of a European patent attorney. According to the EPI, that is the Institute of Professional Representatives Code of Conduct, the task of a European patent attorney includes serving as a reliable advisor to persons interested in patent matters and serving the interests of his or her clients in an unbiased manner. How do we serve the interests of a client? We do this by advising the clients about patents and the patent system in general, and in particular about official requirements of the patent system and of the European Patent Office. And we also perform those tasks that are set according to the client's requirements. Such tasks include, for example, filing and prosecuting a European patent application, filing or defending an opposition, providing an opinion, and so on. We serve our clients in a partisan capacity, meaning that we take the client's side and interest. We must have no conflict of interest at the same time, and our stance is unlike that of the European Patent Office, who take a neutral stance for all applicants and who don't take sides. We, in defending our clients, take sides. Generally speaking, we try to please the client and we try to obtain the maximum possible result useful for the client. Let's now turn to what clients are like. Clients are different from one another. They have different technical and technological backgrounds. They have various resources, from being very rich to medium to quite poor. Each client has its own individual requirements. The clients of attorneys in private practice have somewhat different treatment to the clients of patent departments in industry, but if you're working in industry, you are still serving the interests of clients. And different clients have variable knowledge and experience of the patent system. Some clients are participative and prompt. Other clients are awkward, demanding, and slow. It follows that each client is unique, and we have to adapt our efforts according to the client's needs and resources. Different clients, therefore, get different treatments. Now, to become a European patent attorney representing clients, what do you need? You need to become competent in acting for clients, and for this, you need practice in acting for clients. You now have, with the EQE, a golden opportunity to practice acting for your very own client to gain experience. And for this client, you can make mistakes without compromising real interest. There's no harm in making mistakes during your exam preparations, providing you correct your mistakes and learn from the corrections. For the EQE, then, we're going to consider that the examining organization is your client, and we are going to endeavor to meet up to this client's expectations, and we act for the client as a function of the client's instructions. So we will now turn to the subject of instructions. Patent attorneys take instructions from their clients, from nobody else's clients, only their own clients, and only from clients. We do not take instructions from the European Patent Office, and not even from the President of the European Patent Office. The EQE's instructions to candidates that you receive before the examination and are available in the regulations are instructions to you as a would-be patent attorney. Such instructions can only come from a client because you accept instructions only from clients. So therefore, you have to consider that the EQE Examining Board is your client. These instructions from the client explain how the client would like its patent attorney, you the candidate, to perform the task it sets. Now it's time to get to know our EQE client. You can consider your EQE client as a 50-50 joint venture between the EPO, the European Patent Office, and the EPI, the Institute of Representatives. You can consider the client as a sort of multinational with several subsidiaries, and it will be these subsidiaries who will be sending you instructions for the different papers. Now, the EPO side of the client insists that you should comply with all official requirements, and in fact, the EPO would like us to comply with all official requirements instantaneously and immediately, so there would be no examination procedures. The EPI side of the client, on the other hand, is concerned with obtaining the maximum result or the broadest protection possible, which is not a matter of concern for the EPO. And these two requirements are combined, and there is no compromise between these two positions. You have to comply with all requirements, and you have to get the maximum result, and you have to do it instantaneously. The duality between these two positions of the client means that the EQE client is going to be a difficult client to please. How then does the EQE client manifest its requirements? You can find out about your client's requirements from the following sources: the examination regulations that I recommend you should read, and from the client's instructions, which, as I said, are sent to you before the exam and set out how the client would like you to tackle each paper. You also receive specific instructions for the individual tasks in the different individual papers of the exam. And as an example of this, I can give you is in the drafting paper A in recent years, the client has always said that he's not prepared to pay any extra fees for the claims, which means that you mustn't draft more than 15 claims. That's an instruction given by the client of the day, as it were. In addition, you have a very important source of information about your client in terms of the feedback from the examiner's annual reports for each EQE paper that I recommend you study when you are doing past papers. Always compare your answers with the examiner's reports. Now I'll turn to the client's overall requirements for all of the tasks in the EQE. First, you must meet up to all requirements of the EPC and the PCT, and this includes substantive requirements such as novelty and inventive step. Secondly, you must comply with the guidelines. Note that the guidelines are instructions from the president of the EPO that are more or less binding on examiners of EPO examiners, but are not binding on European patent attorneys. However, if your client instructs you to comply with the guidelines, then you comply with the guidelines because your client has instructed you to do that, not because the guidelines are binding on you. You also have to rely on up-to-date legal sources, that is, up to 31st of December of the year preceding the exam, and this means that you have the task of keeping your legal sources up to date. Lastly, as an overall requirement, you have to accept the given facts in the different papers and limit yourselves to the given facts in your answers without using special personal knowledge. And I would add that in addition to accepting and limiting yourselves to the facts, the client expects you to make the maximum use of the facts to achieve the set tasks. Now let's turn to the requirements for paper A. For paper A, which is drafting, the client expects you to produce in your main claim or your main claims the broadest useful protection for the client based solely on the given facts. And you are expected also to meet up to all legal requirements, which for drafting include things like novelty, inventive step, unity, clarity, proper division of a two-part claim, and so on. You are expected by the client to produce a set of claims that is structured logically, and there should be maximum 15 claims, as I said. Your dependent claims should be generalized or generic. You are not expected to provide trivial subclaims. You also have to produce an introduction to the description according to Rule 42.1, subparagraphs A to C of the European Patent Convention, and I recommend that you structure your introduction exactly according to the sequence prescribed by that rule. You are not expected to provide a detailed description beyond the examples or the drawings. Lastly, you are expected to provide a set of claims and an introduction for one patent application only, And although you have the possibility to suggest separate claims for a different aspect, this is often ruled out by the facts of the case, by the client of the day, and in recent exams, filing a second application has never been appropriate. Filing or proposing a second application has never been appropriate. Now, what comments can we make about these requirements for paper A? The requirements then for paper A correspond to those of a client who wishes the patent application to be accepted immediately. By immediately, I mean that will lead to a positive written opinion followed by direct acceptance without any communication being issued raising any objections. And also where the provisional protection from the publication stands up. In other words, the provisional protection shall be as broad as possible from the initial stage. Such clients now would possibly use the PACE program, but a request for the PACE could be counterproductive if your application were badly drafted. So you must not badly draft your application. Your application has to be perfectly drafted. Your success in meeting up to the client's requirements for the drafting paper A depends essentially on the valid breadth of coverage of your claims, which will cover all of the client's embodiments in the broadest possible fashion. Now, all clients, all European patent attorneys should be able to draft patent applications or implement these requirements if they are required to do so by a client, even though these instructions may diverge from usual everyday drafting practices. They are still perfectly normal practices for a European patent attorney, so you should be able to do them. Let's now look at the requirements for paper B. Here, the client requires you to present a reply to the communication from the European Patent Office where the examiner cites novelty-destroying prior art, where you have to salvage the maximum protection compatible with the client's interest, and where you have to meet up to the following three requirements. First, you have to amend the client's claim proposal as necessary to meet up to all legal requirements. And normally what will happen is that the client will propose a claim amendment which inadmissibly adds subject matter, and you will have to correct that in your answer. Secondly, you have to provide arguments, detailed arguments, to support each relevant legal consequence that you reach, and these in the amendment paper would be basis of amendment Article 1232, clarity, unity of invention possibly, priority possibly, and definitely always novelty and inventive step. And your arguments in support of inventive step should follow the problem and solution format. Note that most credit is available for the inventive step arguments, and in the problem and solution presentation you are going to follow a definite structure or definite plan which will be in sequence: closest prior art, distinguishing feature of the claim over the closest prior art, the effects or advantages achieved by the distinguishing feature, the objective technical problem that has been solved, its solution, and reasons why the solution was unobvious. And you have to treat each of those separately in sequence. let's now comment on these requirements for paper B. The requirements of the client for dealing with paper B correspond to a client who wishes the patent application to be accepted immediately, and immediately here is subject to further amendment of the description, which you are not supposed to do, and it means that the patent application will be accepted without any further communications, interviews, or oral proceedings. Your success in meeting the client's requirements for paper B depends on providing clear and decisive amendments, which means that you have to correct as necessary the client's proposal, backed up by convincing arguments. So you have to put in arguments are going to be very important. Now, all European patents should be able to implement these requirements to the client, and as a matter of fact, I recommend that you, in your practice at work, you should follow the same sequence of the reply letter as you would for the exam. You use exactly the same letter format at work as for the exam, so you get good practice for that. Note that in the B paper, so far the client has always presented you with a communication from the European Patent Office where the EPO examiner's objections have invariably been well-founded, so you are not expected, at least normally in the exam context, to contest the examiner's position. This contrasts somewhat to our everyday practice, where it's usual for us to contest the examiner's objections because they are sometimes, or perhaps often, not well-founded. So that is a difference with everyday practice. We will now turn to the client's requirements for paper C. In paper C, the client requires you to prepare a notice, or in fact a statement of opposition, based solely on the facts supplied, where, and then we're going to go through the conditions. Firstly, you present all good grounds of opposition, leaving aside Article 100B, which is sufficiency of the disclosure or insufficiency, and you must present only good grounds of opposition, which means that you have to leave aside poor or weak grounds of opposition, spurious grounds, speculative or tactical grounds of opposition, which means that your examination statement of opposition is going to go against the practices of many opponents in real-life oppositions. You are expected to attack all claims if possible, and so far in the exam, if possible means always. It's always been possible to attack all claims in the opposition paper. You are to present your arguments in a claim-by-claim sequence, separate claim-by-claim, which means normally you start with claim 1, claim 2, claim 3, and so on. And preferably you will identify the arguments with a claim ground document sequence, by which I mean, for example, the attack against claim 2 will be introduced, claim 2, lack of novelty, over document D3. You also have to use the inventive, for your inventive step, your arguments against the inventive step, the problem and solution format, and we note that the requirement to use the problem and solution approach comes from the instructions to comply with the guidelines, plus the examiner's reports, which make it absolutely clear that you're expected to use the problem and solution approach, plus the fact that all of the C papers have been so constructed that it makes it sensible to use the problem and solution approach for lack of inventive step. Do these requirements now call for any comments? The client's requirements for paper C are compatible with a notional opposition by an ethical opponent against a fictional patent, which means that the client's requirements have got little or nothing to do with real-life oppositions. Your success in meeting the client's requirements for paper C depends essentially on presenting good arguments against the patentability of all claims based on and making maximum use of the given facts. Note that practice on real oppositions, if you have been dealing with real oppositions, I'm afraid to inform you that what you have been doing at work on real oppositions is unlikely to prove very useful as preparation for paper C, because paper C is limited to producing a statement of opposition in very specific conditions that you don't meet in real life oppositions. On the other hand, the exercise or the work that you put in preparing for paper C by doing past opposition papers should prove very useful. It should prove invaluable later. The day when you are faced with drafting a statement of opposition in a real opposition, the work you have done on the opposition papers is going to be very, very useful for you. We'll now turn to the client's requirements for paper D. Paper D is a single paper which is divided historically into two parts, D1 and D2. For D1, which are the short legal questions, the client requires you to provide reliable legal advice. That's the first requirement. And providing reliable legal advice means correct legal advice based on up-to-date legal bases. And you're expected also for D1 to answer the client's questions based on legal reasoning, and you must, absolutely must, identify the legal basis that you use. Those are the three requirements for D1. For D2, which is the legal advice or the legal opinion, the client requires you to firstly develop the legal consequences of the complex situation, which means that you have to break down the complex legal situation into individual legal situations which are dealt with by individual legal provisions and apply the facts, and you develop the legal consequences. And secondly, you must provide sound legal advice in reply to the client's questions. And thirdly, you are expected to advise the client without having to identify the legal basis that you use. Now let's make some comments. First of all, providing reliable legal advice, as I mentioned earlier, is a fundamental part of the patent attorney's job per the definition of the EPI Code of Conduct. And this important part of the job is tested in paper D. The requirement to identify all legal basis in D1 corresponds more or less to our dealings with the European Patent Office, where you can always quote the legal basis. For example, each and every paper, communication, notice, summons, what have you receive from the European Patent Office always contains the legal basis of whatever they are talking about. When you reply to the European Patent Office, you can always, and you should always, quote the legal basis of whatever you are talking about, and that will give you good practice quoting the legal basis for the D1 part of the paper. This requirement to quote the legal basis departs from our dealings with most clients, where you advise without stating the legal basis, as is now the case for the legal opinion in paper D2. The requirement to identify the legal basis for D1, however, implies that you must make a systematic and long-term preparation of your legal sources over many months and possibly over several years to prepare for the D1 questions, which means that the preparation time that you put in for paper D1 of the exam is out of all proportion to the credit available for that in the exam, but it's a necessary part of your legal development to get you into the habit of always identifying your legal basis. The D2 paper, on the other hand, is contrived to test your ability to legally master a complex legal situation, and the fact of identifying a legal basis is not required in D2 nor in the normal client relationship. Here then are some comments on the client's overall requirements for all of the papers of the EQE. First, your client provides you with a coherent set of instructions that follow a uniform policy for all of the tasks in the exam. This policy can be expressed as follows: maximum result, full compliance, and optimum use of the given facts. This means you can adopt a uniform approach for all papers of the exam, maximum implementation of each task based on the given facts. By maximum implementation, I mean for paper A, you have to get the broadest possible valid claims. For paper B, you have to have the maximum support for the amendment by maximum arguments. For paper C, you have to have the strongest possible opposition against all claims. For D1, you have to quote the maximum amount of legal bases. For D2, you have to provide all useful advice based on the maximum amount of legal consequences that you have developed from the situation. This means that in all of the papers, the facts are they are all important, and the facts merit separate discussion. As a matter of fact, clients request patent attorneys to accomplish various tasks, and the clients should provide the attorney with the facts necessary for accomplishing the tasks. In real life, however, real clients frequently give incomplete instructions and supply incomplete facts for completing the task. Attorneys should know, and you should know, what facts are needed and you are trained to obtain the required facts for whatever task you are dealing with. And you do this by questioning the client and by searches. You do that at work. The EQE client, on the other hand, supplies you with all of the facts necessary for the given task and expects you to make use of the given facts. How do we make use of these facts? During the exam, you don't have any access to the client and can't ask questions to the client. The papers of the exam are a manifestation of the client's intentions and contain all necessary facts. You can find out all of the facts that you need by asking questions to the paper, and I suggest that you practice reading and asking questions to the papers, and during the exam I would just advise you to ask those questions silently. Therefore, in the EQE, all of the facts you need are in the supplied papers. You have to identify the facts by reading the paper. Then you have to plan what you're going to do with the facts. And lastly, you have to extract the facts from the papers and insert them into your answer. This corresponds to the working method read, plan, write that I will deal with in the next tutorial on the working method. In everyday practice, before you start asking your clients for more information, always read and reread the information the client has supplied already to make the maximum use of that information and to focus your questions as clearly as possible. Now, all this about facts, in my opinion, is because I consider that the EQE client is obsessed with the use that you make of the facts in the EQE. The EQE client is convinced, correctly in my opinion, that making good use of the facts is an essential attribute of a qualified European patent attorney, and so the use you make of the given facts in the EQE is going to be taken by the client as a barometer of your competence. It follows that the use you make of the facts is going to be crucial for your success in the EQE, and it means that you have to strive to make judicious use of all relevant facts furnished by your client at work and for the EQE. The subject of facts leads me to preview the paradigm fact, legal provision, legal consequence. This paradigm is as follows. When facts are applied to a legal provision, they produce legal consequences according to the paradigm fact applied to legal provision produces legal consequence. That is, relevant facts. In all EQE papers, the client supplies you with all of the relevant facts needed for producing the legal consequences that are necessary to complete the task that they have set for you. So, to respect your client's instructions for all papers of the EQE, you have to focus on facts that produce legal consequences relevant to the task at hand. I will amplify the paradigm fact, legal provision, legal consequence in the later tutorial, legal thinking. I'd now like to consider some aspects of taking on a new client. A European patent attorney taking on a new client in a new area enters into a two-way relationship. On the one hand, the patent attorney learns about the client's technology and about the client's interests by asking the client questions he needs to perform the given task. On the other hand, the client learns about the patent system from the patent attorney and acquires a patent culture by asking questions how to protect his technology. I suggest that you try and develop a fruitful two-way relationship with your new EQE client and not a one-way relationship. You should learn about the EQE client's interests and the tasks he presents to you, and at the same time learn about the features of the European patent system tested in the EQE. At the same time, you should tell the client what you know about the patent system. In other words, you should educate the examining committee about the patent system in response to the questions asked and by accomplishing the tasks set. Now I turn to working for the EQE client. When you enroll for the EQE, you are entering into an attorney-client relationship with the EQE Examining Organisation. As I have mentioned, you should take care to find out about this client's expectations. In all your work practicing on past exam papers, always do your best to please the client by complying with the requirements. Now, working for this client over several years during your exam preparations is going to provide you with valuable, or I'd say invaluable, experience for your future career as a qualified patent attorney. If you don't meet up to expectations because you don't follow the client's requirements, you could be unsuccessful in one or more of the papers of the EQE, but don't worry too much about having to repeat one or more papers of the exam. Repeating papers can be a very rewarding experience because it forces you to very carefully consider the client's requirements. Now I would like to make a digression about communicating with your client who is more or less deaf and dumb. Your working relationship is exclusively in writing. There are no oral proceedings and no interviews. All questions from the examiners or your client are put to you in writing with drawings if needed. You have to make your answers in writing within a set time, and you have to put down your answers in handwriting, and as the handwriting is done in a fairly short time, it could be difficult to maintain legibility, but you should know that the client, that is the examiners who read your papers, are experts in deciphering illegible handwriting, not that I encourage you to write illegibly. If necessary, but more often if you feel the need, and if you are from a country with a language, a different language, you can use your national non-EPO language in the exam, either for fully replying to the questions, or you can mix. For example, in the drafting paper, you could write a claim with the pre-characterizing clause in English and the characterizing clause in Italian or Spanish. And that is accepted by the examiners because they know how to read also in those languages. You are not, however, expected to explain what you have done or why you did it to the client. You are allowed to make comments, but making comments or writing notes to the examiners is not to be recommended. If you do something correct and you write a note to explain why it was correct, the note is superfluous and is a waste of time. If you do something wrong and you write a note to explain why you did it wrong, it could make matters worse, or in any event, it's simply a waste of time. So it's not a good idea to plan to try and get into contact with the client by making notes. Communicating with this client then is special, and it could be of interest to know how this client pays you or how the client rewards your efforts. In real life, clients reward patent attorneys' efforts by paying them a salary in industry or by paying invoices in private practice. the invoices being in proportion to the amount of work done. The EQE client will pay you by awarding marks for the different tasks, and as each task has to be done in a set time, the examiners expect a certain amount of work to be done in that time, in other words, for you to produce a certain result. The marks awarded are more or less in proportion to how well you implement the client's requirements. The amount that you get paid in the exam, or your result in marks, you find out about 6 months after the exam when the results are announced, and you can find out more or less how the marks are allocated by studying the examiner's reports. More on the next slide. By practicing on old exams and by comparing with the examiner's reports, you can gauge what you will be paid or what you think you ought to be paid for your efforts. It gives you a reasonable idea of how well you are doing. During the exam itself, on the other hand, you have no accurate indication of how the client allocates the marks and how you will be paid for your efforts. This applies even to the shortest D1 question. For example, a D1 legal question is awarded, so it's 6 points or 8 points, but you don't know, you know that 6 points will be allocated, but you don't know for what they are allocated. If you follow the client's recommendations, and if all goes well, the client will reward your efforts with a pass in the exam, which represents a passport to professional competence. Passing the exam is a really rewarding experience. It compensates you for all of the efforts you put in your preparations for the exam, and it releases you from the doubts that may have built up in your mind in the transitional period while you were trying to reach the qualification standard. Passing the EQE then goes hand in hand with termination of your status as a candidate, which leads me to the next slide, which is about getting rid of this client. During most of your career, that is not in the exam, you will normally try to please your clients in the hope of developing a satisfactory long-term relationship where the client keeps sending you work and you keep your employment. With the EQE, however, the EQE client, it's different. Once you have demonstrated that you can meet up to all of the EQE client's expectations, the client fires you as its attorney in training and puts an end to your career as candidate. Think of it this way: how do we get rid of clients? There are different ways of losing clients. For example, if you do shoddy work, if you are untimely, if you are overcharged, if you are nasty with the client, if you neglect the client's work, you can expect to lose a client. But with the EQE client, it's somewhat different. As long as you keep disappointing him, he's going to remain as your client, and the only way to get rid of the EQE client is to meet up to its expectations, that is, to perform well. I suggest that you make as an aim to get rid of this demanding client as soon as practically possible. And then what will we do once we are rid of this client? As I said, passing the EQE is a passport, and it's a passport to a rewarding professional career. But you are no longer allowed to sit the papers of the EQE, so you can pursue your career working for your clients or your employer, and that's fine. You can take on new responsibilities and you can progress in your job, you can change jobs and so on. Nevertheless, if during your preparations for the EQE, you became fond of the EQE client, in other words, you liked working for this EQE client, you can still continue working for this client in different ways. One way is as an examiner in the examining committees, where you will have the opportunity to judge the competence of future generations of trainees. Or you can join one of the tutorial schemes as a tutor, assisting future candidates in their work for the client, and therefore continue your good work for this client, explaining to the new candidates what this client needs. In the meantime, as you continue in your endeavors to satisfy the EQE client, you have plenty of work in store. So what's next? Next, in this series of tutorials on approaching the EQE is a tutorial entitled The Working Method that I mentioned before. In this next tutorial, we will investigate the three essential phases of the working method, which are, and these are essential phases for all papers of the exam and for all questions of the exam, even for short legal questions. Phase 1 is read, which is purposeful assimilation. Phase 2 is plan, which is organization and planning. And phase 3 is write, which is delivering the end product. I look forward to your participation in this forthcoming tutorial and the following tutorials in the series. Now I have some closing words. This brings our tutorial on serving the client to an end. I hope it has been of value to you, and I hope this tutorial and the others in this series will help you to make the most of your preparation and help you to keep the amount of your preparations to a reasonably low level. I also hope it will help you to acquire professional competence for your own benefit and for the benefit of the real clients you serve. Be on the lookout for upcoming tutorials on other EQE subjects that I will announce on the Pat Skills blogspot. For further guidance on EQE preparation, you can, and I recommend that you do, consult the book EQE Comprehensive, which is available on the internet from the site shopmybookallinoneword.com under the search word Pat Skills. À bientôt.